मेरे को इंट्रोड्यूस नहीं करना, आज तक किससे मीटिंग में था। आप और सुन रहे हो ना?
होस्ट ही हैं सर, आई एम द मॉडरेटर।
ठीक है, ठीक, ओके ओके, ठीक है, कोई इशू। देखना सर, हो गया ना, हट गया ना, अब देखो, हो गया, पोज हो गई, ठीक है, देखिए।
So, good evening, all the professional colleagues. A warm welcome to all. Myself, CA JP Jain, welcomes you all in the today session on the behalf of our team, Professional Gyan Kendra. Hope our professional friends, their families, and close ones are safe and doing well in the pandemic situations. With this, I would like to initiate today's virtual meeting on the Company Act, that is for the topic discussion on the company under startup and strike of companies under the Company Act. That would be taken up by guest speaker, respected CS Gaurav Agarwal ji. Welcome Gaurav sir on the behalf of our team Professional Gyan Kendra, and thank you for sparing your precious time out of your busy schedules.
Thank you.
So I request CA Vijay Mittal ji, the founder of our member of Professional Gyan Kendra and the chairman for this session, to say few words and introduce our guest speaker for the session. I would like to thank Vijay Mittal ji for bringing us together by means of this knowledge sharing session with such an experienced member of the our CS fraternity. Over to you, Vijay Mittal ji. Thank you.
Good evening, friends. Good evening, all the participants. Myself, CA Vijay Mittal. I welcome all the viewers on behalf of Team Professional Gyan Kendra in the today's session. As JPG told that the topic of the today's session is company startups and strike of companies under the Companies Act, and that will be taken up by our guest speaker, CS Gaurav Agarwal ji. I welcome you, Gaurav ji. Thank you for coming and sparing time for the knowledge sharing session. I would like to introduce CS Gaurav Agarwal ji. Gaurav Agarwal ji, the member of the Institute of Company Secretaries of India. He is a bachelor in commerce and also master in commerce, has a very sound knowledge of the FEMA Foreign Exchange Management Act. He is also having a very sound knowledge of the Companies Act, also having a very good experience to work with the listed companies, and having a very good exposure of the corporate secretarial compliances. Lot of experience, exposure, a young and dynamic person, CS Gaurav Agarwal ji, having a very good academic background, and we are going to learn today from Gaurav ji, and I hope that it will be a value addition to all the persons who are doing work in companies like strike of companies and startup in under Companies Act 2013. Now I would like to over to Gaurav ji to please start the session.
Hello.
Over to you, Gaurav ji.
Thank you, JP Jain ji, for inviting me. Thank you, Vijay Mittal ji, for inviting me for this session and providing enlightening my members with my knowledge and on the topics of this strike off of the companies as well as startups. So thank you for giving me this opportunity. So can we start now, Vijay?
Yes, Gauravji, please.
Oh. Yeah. So today we'll be discussing about some of the provisions, some of the uh, difficulties faced by our professionals in regards with the strike off of the companies and also with respect to the startup registration. So I'll try to brief as much as I could. So now let's start with that. Now, the strike off means if a company is incorporated under a Companies Act 2013 or or any of the previous act like Companies Act 1956. So, if the directors or the shareholders are of the interest that they doesn't want to run the company, or the ROC itself, Register of Companies itself thinks that there is a need that this company should be shut down. So the procedure of this is called the strike of the company. Like it's a removing of the name from the register of companies, which is maintained by register of companies. So after that, the procedure starts in the two ways. There are two modes through which the strike off can be done. The first mode is by the ROC, that is suo motu, and the second one is by the company itself, that the company directors or the shareholders, if they want that, then they can strike off the company, right? So first we're discussing about the strike off being done by the ROC on suo motu basis. So section 248(1) governs the provisions of this, which says that ROC on suo motu can ask the company and can allow or can like strike off the company. So the process will be started as like this. The ROC on being seen that the company is not so operational, or there are very much grounds which I will be discussing later. So on these grounds, if the ROC is thinking that the company is not in operation, or the operations of the companies are not as per the law, so they can give the notice to the directors as well as the shareholders of the company, basically the company only, in form STK1, stating that the ROC is thinking that they will be striking off the company and giving the shareholders and the directors opportunity of being heard in that regard, to give a reasonable cause why the company should not be struck off from the register of the members. After that, after receiving the notice, the directors have 30 days period for replying to the ROC. And in case they are not able to reply to the ROC with the sufficient reasons, then ROC might, after releasing an advertisement in the newspaper, that is Vernacular newspaper, strike off the company. And in STK 7, the letter or the order of the strike off will be issued to the concerned company and its directors, right? Now, there are some of the grounds which ROC, which as per the act, ROC thinks that they are the grounds through which the strike off can be done. So some of them are like this: if a company is incorporated, say it's today, if the company is incorporated, and from today onwards, from the next 1 year, they're not able to commence any kind of business. So since a person who is incorporating a company, it is deemed that he will definitely be commencing the business sooner or later. But since if you're not commencing from the 1 year, then there is a valid ground to ROC to strike off your company, because it's making an unnecessary record or unnecessary hassle for the ROC to maintain the records of that company. The first rounds will be that if you are not able to commence the business within 1 year, then you will have to be, well, ROC if thinks, then can issue an order for strike off. The second one will be if a company is not in a position to start its business, then there is an option in the act to take the status of a dormant company. And the section which governs that is section 455. So it clearly says that if a company is not running its business, but they have a capital, they have some kind of what we say, some kind of assets, and they want to maintain that asset for the future business, they can just take the filing the form, they can just take the status of the dormant. And with that regard, they just need to do the annual filings, nothing that, but they don't want to reserve, don't want will be starting the business. And this status is will the company for the 2 years, like from the incorporation for the next 2 years, they can be a dormant company. And if they have not taken that the status, then automatically you falls under the provision of the first subsection, that is you have not commenced any business and you're liable for the strike off of the company. Okay, now the third one is that it has been referred in section 10A subsection 1 that every subscriber need to pay the subscription money which he has subscribed for the shares within the 180 days from the date of the incorporation. If the subscribers are not able to pay the subscription money within the time limits, so that becomes a ground for the ROC to strike off that company. And there is a form called INC20A which need to be filed to the ROC for commencement of business, that was earlier been removed when the New Companies Act was introduced in 2013. But recently with an amendment, this form and this procedure for taking the commencement or informing the commencement about the business need to be filed with the ROC. And this form need to be filed within 180 days. So if you are not able to file with the ROC with this form, so this become an grounds for the ROC to just have strike off the company. Now the last one will be that if in case like ROC thinks that might be the client be showing that we are running a business, but ROC has the power to inspect the business premises, business operations, and all these things physically. And if the officers after inspections thinks that there is no business been carried out, or the activities for which the company was incorporated. For example, the object was a company for a pharma, and the company is altogether doing a different business, for example, in the auto sector. So they have a reasonable ground to strike off the company, as the facts and the papers submitted to the ROC are totally a wrong one, as you have taken the permission for the pharma sector, but the client is working for auto sector. So this becomes a valid ground for the ROC to strike off the company. Now coming back to the second mode, which is the strike off being done by the company itself. So it says that a company may also itself apply to the ROC that please strike off a company. The procedure and all these things, they need to file a form, that is STK2, to the ROC for in respect of requesting the ROC to strike off their company. But before filing any kind of form, they need to fulfill some of the conditions. The first condition will be they need to extinguish all their liabilities. Like we need to submit a statement of accounts with the ROC stating that we don't have any kind of assets or liabilities, that the assets and liability portions are almost a nil one, and we just there is no creditor at our end. So the extinguishing all this liability, and by passing an SR or 75% of the consent, if it is taken in the AGM or EGM, then the company can go for the strike off. Like, but over here there is something which need to be understood by the members. Like passing of SR. SR definition is like number of votes that has been casted. So two-third percentage if is in the favor, then a resolution is deemed to be passed. So over here, the Act has defined it in a two-way. The Act has given the liberty to the company in a two-way. Either pass the SR. If you're not able to pass the SR, then the whole percentage of the members, like if you have 100 members, for example, for say you have 100 members, so out of that 75% should give their consent. If any of the conditions you fill, like if you pass the SR, or if you are able to take the consent of 75% of members, then you are eligible to get file the form STK2 with the ROC, and thereafter your strike-off procedure can be initiated by the ROC. For filing this form, government fees of 10,000 is been prescribed by the ROC. So earlier it was 5,000, but with the amendment in the Miscellaneous Fees Act, so it has been amended now. It is now 10,000, and various other attachments need to be filed with the form STK2 in order to comply with the conditions as prescribed by the Act and to make the ROC to proceed with your company strike off. Now, coming up to the what the procedures, what the process the companies need to take in order to strike off the company or in order to start the process of striking off the company. So the first one will be the hold a board meeting. Now, as per sectoral standards, the board of directors or the person, anyone authorized by the board, need to send the notice of the board meetings at least 7 days before the board meeting to all the board of directors. Thereafter, the board of directors will pass a resolution that they want to discontinue with the company and they want to strike off the company by filing the forms with the ROC. After the resolution is passed, then all the liabilities in terms of its creditors or any other liabilities will be disposed of, extinguished, so that none of the stakeholders is affected with the striking of the company. And thereafter, in the board meeting only, they'll arrange, they'll just give the notice, they'll approve the notice of the annual general meeting, they'll organize the general meeting, and a 21 clear days notice period will be served to all the shareholders of the company for requesting them to take the consent for striking of the company. And in that general meeting, either we need SR to be passed, that is a resolution to be passed, or we will be needing some 75% consent of the total number of the members. And if we get the consent, and then we can go ahead with the STK2 form with the ROC for striking of the company. Now, the fourth point says that approval of the concerned authority. Sometimes it happens that our company is governed by some other act also. For example, RBI Act, for example, Insurance Act, if it's an insurance sector company. So ITRA or RBI approvals need to be required. So in that regard, if we are going to strike off the company and we are covered with the other acts as well, so we need to take the approval of other concerned authority as well. And we need to annex the same approval with the form so that there is no future complications from the company. And thereafter, when all the approvals with regard to board, with regard to shareholders, with regard to concerned authorities like RBI, IDRA, and all these things. So thereafter, you can file the STK form, and thereafter the procedure for that will be started by the ROC. The procedure at the ROC end will be like that. The ROC will first inspect your form with regard to all the legal requirements, and thereafter they'll just in case of any queries, they'll just raise the queries, they'll send the form for the resubmission. And if you submit all the documents, then you can just go for striking off the company. Then the form is approved and the status on the MCA website will be shown as under the process of striking off. One thing I would like to enlighten to all the members that strike off is in a stages. Like if it is not a process of a one time, it takes around 1 year or maybe 6 months to 1 year to have the fully striked off the company. Initially, when the board starts with the approvals and all the approvals are taken and the form is filed, thereafter the ROC inspect the form STK2, and if the form sounds good, they just accept the form and intimate the directors and the company about that. And thereafter, the status is converted from an active company to a under process of striking off. Thereafter, after the status of the company is changed from under process of striking off, then the ROC will make a public advertisement in format of STK6, stating that this company will be striked off in a near future. So all the stakeholders, be it a public, be any person who have any kind of relation with the company, can just raise their queries, or if they want that this is not up to the mark, that this not should be striked off because their interest will be hampered. So this they can just they can send their queries to the ROC, and if the ROC found it a feasible one, then it can stop the process of striking off, even if the ROC has approved the form STK2. So they need to see any other interest, because might be sometimes company might hide that some of the stakeholders have have issues with the company, but the companies are trying to hide that issues. So in order to protect the rights of the stakeholders, the ROC will be advertising your company with that, and that they will saying that this observations has been made by the stakeholders, and the company is required to answer the all the queries and all the concern raised by stakeholders. And thereafter, if the ROC finds that the company is correct on his part, he can just order for the strike off. And thereafter, I guess normally in the practically, I must say that it take around 6 months to 1 year to get the company strike off totally. One more ground which I forgot to mention over here, for sorry for that, but that would be if the company is not carrying on any kind of activity from the last 2 years. For example, the company has been incorporated for many years, but from the last 2 years, not even single activity of any kind has been conducted by the company, neither a revenue nor an expenses, then it is a valid ground for ROC as well as the company to go for the strike off level, to go for the strike of the company. So one thing which we usually miss out is that over the act, it is written that 2 financial years. It is clearly mentioned 2 financial years. So 2 financial years means like from 1st April 1st April to 31st March. So if a company is not having any kind of transaction, any kind of business from the last 2 financial years, then they can go for the strike off easily and by filing out the form STK2. Now, there are some types of the companies which are been exempted by the ROC under the Rule 3, which cannot file the form STK2 or which cannot go for the strike off. These are listed companies. As listed companies are governed by the SEBI Act also. So there is a proper format which has been prescribed in the listed companies cases, which need to be followed by them in order to, first they need to delist themselves, and then they need to file number of applications, and thereafter a listed company or a SEBI will give an order, and thereafter you can go for the strike off. So listed companies cannot go directly to the ROC for striking off their company, as the listed company has many shareholders, like they have ample amount of shareholders. So the rights of all the shareholders might get hampered. So they're not allowed to, they're not just allowed to have this strike off provisions with them. Now, the second one is the company which has delisted due to the non-compliance of listing regulations. Now, since some of the companies are there which are not following the listing regulations, especially in the LODR ones, listing obligation and disclosure requirements. So the ROC has clearly said that these companies will not be allowed to strike off themselves, as these companies might be involved in some kind of a fraud, or there are some kind of penalties pending with them. So these companies will not be covered over here. The third one is a vanishing company. A vanishing company is a company which from the last 2 consecutive financial year is not filing any kind of returns, is not filing any kind of statements with the stock exchange. So these companies becomes the vanishing companies. They are not delisted the companies, but they are a vanishing company, like they are now not reporting properly. So these companies are also not required to go for the strike off under the section 248 of the Companies Act 2013. Next one is the companies for which any kind of prosecution, investment, inspection is pending. So till the time the prosecution, inspection is pending, they cannot file the application for strike off. And next one is the company under compounding. If any compounding has been filed by the company for a default being made by the company to the tribunal, that is NCLT, or to the High Court, or to the ROC, so till that time the compounding order is being received, and the liability in case arises is being the contingent liability in case it has become the liability. In case it arises, then they need to just vanish that, and after that they can file the application for strike off. The next one is that if a company has taken a public deposit as per the section 73 of the Companies Act, so and if there is a default in repayment of that deposit, so until then, unless the company makes clear that default and repay all the deposit, they are not they're not liable, they're not acceptable to go for the strike off. As if the company strike off, then the interest of the deposit holders will hamper. And Section 8 companies or under the Companies Act 2013, that is mainly the NGOs and all these things, non-for-profit organizations. And as per Section 25 of Companies Act 1956, these companies are not at all um, allowed to go for the strike off, regardless of that they are a clear companies, they don't have kind of any liabilities and all these things. Still, they are totally exempted from the provisions of this act. Now, since I mentioned above that that the dormant status, that the companies can take the status of dormant, and thereafter they can just file the returns, that is the annual returns, and mm, be active, be a active company in terms of the register of the companies. But if a dormant company also doesn't file the annual return within 30 days from the end of the financial year, then the ROC has a ground to strike off these companies. In this case, the company itself cannot go for the strike off, but the ROC only has the power to strike off these type of companies. And if a default is made with respect to the above section, that is section 455 and the company's miscellaneous rule 2014, then every officer and every company will be liable under the provision of the Companies Act and will be penalized under section 450 of the Companies Act 2013. Now, one more thing is there. Many of the people got confused between the wind up and the strike off of the companies. So many of the persons are the view that these are the similar things, but these are totally different things. They are not so similar. The act which governs them is the same, but the sections which govern them are totally different. The procedure are totally different. The concerned authority listening to the shareholders or listening to the attending the case of the strike off or winding up are different. So it's a big difference between the strike off company and strike off company and a wind up company. So I have put some of the differences over here, like if a client or if a company is a defunded company or having a very limited liabilities and assets on in his balance sheet, then the company should go for the strike off. And if in the case they have a huge number of assets and liabilities, then it is better to go for the winding up. As in winding up, we need to appoint a liquidator. He'll take the charge of the company as a whole. He'll be the sole person who will be handling the company, and he'll just evaluate the assets, evaluate the liabilities, pay off the liabilities, and thereafter the amount left will be distributed amongst shareholders, preference shareholders, security shareholders. So the winding up process is a very lengthy process as compared to the strike off of the company. The winding up petition need to be filed with the NCLT tribunal. The strike off need to be filed with with the ROC itself. We need not to go to the NCLT. But to revive a strike off company, we have to file a petition with the NCLT. So it takes a time around 6 months to revive a company. It depends on the hearing we get, since it's a COVID period. So hearings are not so much frequent, and also they are being conducted through video conferencing. So as per my client also, I am currently handling with this wind up issue. So it takes time to wind up a company with regard to the NCLT. So it's better to, if you have a small company, if you have not so much assets, it's better to go for the strike off, as the procedures, as the expenses are very less in terms of the winding up of the company. The last thing which I would like to tell you about this subject, this topic, would be like, even if the company strike off from the register of the companies and the ROC has given you the certificates in form STK 7, still the liabilities of the directors of the company and the shareholders of the directors of the company stand still. In case in future, if any of the claims arises that are the genuine ones, then the directors of the company can be sued in the court or in the NCLT for the recovery of the amount, and the directors are still liable for that. And another thing which I would like to just informate you that that if a company has changed his registered office or changed his name from during the last 3 months, then they cannot file a strike off application. Usually, practically, what the company is doing, if they change the name or if they shift the registered office from one state to another, so they just wait for the 6 months to get the things neutralized, so that all the stakeholders are able to know what the changes being done by the company, and thereafter they just file the application in STK2. But we recommend that we should wait for the at least to 6 months to 1 year, so that the ROC doesn't raise any kind of objections with regard to the striking of the company. One thing more is there, if a company has taken a loan or something and a charge is created over the assets of the company, in that case, until unless all the charges are satisfied by the company and the company has the NOCs of from all the charge holders, till that time the company cannot cannot go for the strike of the company, as the NOCs need to be attached with the form STK2. And one more thing is there that there are many dilemmas, that some are of the opinion that we don't need to file any kind of annual filings, and some are of the dilemma that we need to do all the filings and then after only we can file the form STK2 or go for the strike of the company. So in the current scenario, in the practical scenario, the ROC is strictly asking for all the annual filings being done properly. Thereafter only you can go for the striking of the company, because in some literal cases, ROC are allowing that the companies can go for the strike off and they need not to file the annual returns or need not to incur the expenses with regard to annual filings. But those companies are the ones which have been initiated, yeah, which have been incorporated a year ago. That 1 year has been only the left, so that things can be over here considered. Otherwise, all the companies are liable to go for the strike off. Now our next topic will be a startup registration. So the startup being recognized much in 2016 by our Honorable Prime Minister Narendra Modi. The startup was earlier also, but they didn't get so much recognition in India. So although in foreign countries, the startup had very much exposure and very much facilities and very much incentives.
मगर सेल्फिंग टाइम ओवर होगा सेल्फिंग टाइम ओवर हो गया
Hello?
सैटरडे बिजी डे सैटरडे तो छुट्टी होता है इज अ छुट्टी डे
All are requested to please mute yourself. All the members are requested to please mute yourself.
हाँ अभी इसमें ब्यूटी में क्या प्रॉब्लम आ रहा है महिमा में हम अपने देख रहे थे इसको 2018 से इसमें
Hello?
हाँ
Hello?
जी,
Yeah.
Continue, please continue.
हाँ जी. So startup did get, I think so. विजय जी, काफी लोगों का माइक ऑन है.
एक सेकंड.
हो गया सर, प्लीज कंटिन्यू.
Yeah, okay. Thank you, sir. So ये है सर कि startup got the recognition, much recognition, and the government also emphasized on the startup in the year 2016 when Honorable Prime Minister Narendra Modi ji encouraged the Indians to bring in the new technologies, new innovations, and to upgrade the existing products, and also gave some of the subsidies and all these things. So startup came into the much interesting part in 2016. So if we talk about the meaning of startup or what is a startup or a startup company is a private company incorporated in the Companies Act 2013 or any other act, previous act, that is Companies Act 1950 or a previous act, or an LLP, registered LLP under Limited Liability Partnership Act 2008, or a registered partnership firm, and that has got recognition from Department of Industrial Policy and Promotion, Ministry of Commerce and Industry. This recognition is most important for a person to be qualified as a startup. Some of the persons are of the view that if we are just going for an application of startup, we are a startup. No, you have to have a certificate, a valid certificate that has been issued by Department of Industrial Policy and Promotions. And if you have that certificate, then only you are qualified for startup. Then only you are qualified to take the benefits with the startup are getting. Otherwise, you are not a startup. You just filed an application, and that does not qualify you for any kind of startup. So when we talk about the startup, the main keyword is the innovation. Now, if you are just innovating a new product or a new services which has not been existence in the public, then you are just qualifying for your a startup. The business which develop a new product, services, or redevelop a product. If for say a product has been already in the market, but since you want that to be properly, or it need an upgradation, and that upgradation is a unique one, so the person can go for the startup. Basically, a person over here means only the three persons. So who can apply for the startup are the private limited companies, partnership firms, and LLPs, like limited liability partnership. Only three categories of the persons or three categories of the entities are allowed to go for a startup or apply for the startup. And the partnership firm need to be a registered partnership firm. A non-registered partnership firm cannot go for a startup. Now, there are some steps which need to be considered while we will be going for the startup registration. Like first, we need to incorporate a business, be it be a LLP, be it be a private limited company, and be it be a registered partnership firm. So the normal procedure for incorporating a company, an LLP, and a partnership firm will be followed, and a SIN number or a partnership registration number will be taken. Thereafter, we'll register with the Startup India website, and will file a form. The form is being submitted online to the startup ministry, DPIIT, and thereafter your application will be scrutinized by the department. In case of any queries, the observations will be sent to the applicant, and if all the things goes well, then the DPIIT give the recognition, and they give us the number of the startup. And after that, we get many more benefits with regard, we'll be discussing in the further slides. So there is certificate being issued by the DIPP, so DPIPP. So after the certificate, there are some of the procedures which need to be filled up so that we are able to start the business. So now the documentation required for registration in startup are the incorporation certificate or registration certificate in terms of the partnership firm, and details of the directors or the partners will be required to be filled over there, and proof of concepts like a pitch deck. A pitch deck is a thing that explains you, or that is your what do you brief introduction or a brief way of how your project or how your startup will be going to work, what all it will be doing, how it will proceed. So it's a complete profile plus the process through which your product, your services will be evaluating, or which will be like manifolding your business. Or you need to send a website link, or if in case you don't have a pitch deck, you can just go for a video. For example, some of the startup have introduced a new machinery, or new technology is being introduced in a current machinery. So what they can do is they just can shoot a video of the process, how the machinery is working, what all the process is doing, and just upload it on the Startup India site. In that regard, after that, the video is being viewed and all these things, and thereafter the startup, if all the things go well, the startup registration is received. And there are much benefits to get a startup. There are cost reductions, there are many subsidies available to them, there are tax benefits. So there are lots of numbers which encourage the people to go for the startup if they have a unique idea or if they have unique products in their mind. And patent and trademark details, if a client or if a company is having a trademark or a patent earlier, so they can file just the details. This helps the client to take the startup at a very easy cost, or very like very hassle free, because since the trademark authority is also very strict in this regard, they don't just allow the trademark to be registered as easily, because as you all know, the trademark registration requires minimum of the 5 months period to get registered, minimum 5 months. So it's a lengthy process to get a trademark. So they also inquire a lot of things. They also go into the deep inside. So if a company is having any patent or trademark, so that is a very good initiative. That is a very good part on the company, and they are much more now to the safer side of getting the PIP, PPIIT registration, and PAN number of the company or her partnership firm is also required. Now the eligibility of the Startup India. Now the startup, as per the act, not all the companies, all the partnership firms are allowed. Even if they have a unique idea, even if their product is a unique one, they can't go just for the startup registration. There are some of the conditions which have been mentioned in the act that need to be fulfilled so that they can go for the startup. The first condition is that the company or the partnership firm should have not been completed the 10 years from the date of the incorporation. If they have completed the 10 years, so they will not be liable, they will not be eligible, eligible for taking up any startup registration. As the startup registration certificate is valid for 10 years. Like the government has clearly mentioned that only for the first 10 years, you will be treated as startup. Thereafter, you will be a normal company running the same operations, running the same things as the other companies are doing. The next thing is that it should be partnership firm, LLP, or a registered LLP and a private company. Only 3 entities are allowed to make an startup applications. No other entities have been allowed till now to make a application. Now, some of the concern that does a foreign company can apply for the startup? So in the current scenario, my answer is a no, because till now the government has not amended. There have been discussions being conducted at the ministry for including the foreign companies to take the benefits of the startup and register themselves as startup, but they have not got the approval till now, and it's in a pipeline. So currently only 3 entities are allowed to take the startup registration. The third condition is the annual turnover during the 10 years of period, which starts from the incorporation of the company, thereafter the 10 years, should not exceed 100 crore rupees. If in any year the turnover of the company exceeded the 100 crore rupees, so automatically the startup registration will get cancelled and they will not be called startup thereafter. Now the fourth point will be like, whenever you are approaching for the startup, the first thing that the applicant should consider is the product or the services. Either they are innovative or they're improving some of the products. Like if the business is being set up and they want to have a startup, so they just need to focus on what innovations they are bringing, how it will help the public at large, then only they should go for the startup. There are some definitions also defined what will be deemed as startup. It's not just that if a product is in market and we are just changing the design and saying that this is an innovation done by us. This is not a startup. It should bring some extra utility to the product. It should bring some uniqueness or some kind of what we say. It should bring some kind of facilities to the customers, new facilities, new utilities to the customers. Then only you can qualify a startup. And if a company is being constructed or it has been formed after restructuring, like demerger, merger, then these companies will not be eligible to go for the startup, even if they have a turnover below 100 crore rupees, or even if they have not completed 10 years. But these companies will not be eligible, for the registration of startup. Now, some of the tax exemptions, which is the catchy area, which everyone want, why we should go for the startup. So some of the tax exemptions I mentioned, there are a lot of tax exemptions being provided by the government, but since we have a time constraint, so we'll cover up a little bit of them. The first one is, the major one is like 3 years tax holiday in a block of 7 years. So this is that the moment we get a startup registration, thereafter, from the date of registration in the startup till the 7 years, the company or the partnership firm can choose any of the 3 years in which they'll will be not liable to pay any kind of taxes. They are totally tax free. These 3 years are these 3 years are the liberty at the company which they want to choose. Either they want to choose the first 3 years, either they want to choose the last 3 years, either they want to choose the 3 years between, like second year, then fourth year, then sixth year. So it's up to them. In a block of 7 years from the 10 years, the 7 years has been defined. The first 7 years, in that first 7 years, only 3 years has been given to the ROC, so to the startups, to just that they don't have to give any kind of taxes on their profits or something like this. The second one is like exemption from tax on long-term capital gain under section 54 EE. So it says that that if a startup is selling any kind of its assets, so automatically it encourages a long-term capital gain on that if it is being sold on the profits. So if a startup is being selling any kind of assets and the money received from those assets is being invested in a funds or in securities specified by the government, then the startups are exempted from giving any kind of long-term capital gains. But the condition which the government has raised over here is that maximum amount that can be invested in these funds is 50 lakh rupees. Above 50 lakhs, you need to go for the long-term capital gains. You need to pay the taxes in terms of long-term capital gains. And the company, when they have invested in these funds, for these funds need to be invested for the next 3 years. If the company is withdrawing these funds before 3 years, then the tax liability again arises and the company need to pay the taxes. So they need to just invest in a fund that has been authorized, that has been told by the government. If they're investing that for the 3 years, then no tax will be paid. They're not able to pay any tax on the long-term capital gains arise from sale of assets. Now, the third one is tax exemption on investment above fair market value. Sometimes your goodwill or sometimes your market value, individual market value, makes your share price much more than the market value. And in case if suppose we have a market value of a share of ₹100 and we are getting 110 as like 110 as our share price, so we're getting a 10 rupees above our market value. So the investors need to pay the taxes on that regard, especially the venture capitalists. So there has been exemptions given to some of the person, not all the person, that are resident angel investors, families, and funds. If these mutual funds and all these things are investing above the market value, then they are not liable to pay the taxes on the above market value which they have paid to the startups. Then the next one is tax exemptions to the individual HUF on investment of long-term capital gain equity shares of the eligible startup under section 54 GB. Suppose the individual or HUF have sold any of the investments, any of the assets, and according to the Income Tax Act, these will attract a long-term capital gains, and thereafter we need to pay the taxes in that regard. So the basic idea before this is to encourage the startup. So if an individual is selling, so for example, his residential property. So as per the provisions of the earlier act, it says that we need to either pay tax or we need to invest the same, either purchasing another house, residential property, or by constructing a house, so that the capital gain does not arises or the tax liability does not arises. So it has been amended now, and it has been said that if an individual, after he got the long-term capital gain from sale of his residential property, invests the amount in the startup and takes 50% or more of the share capital of that startup, then he is not liable to pay any kind of tax. The condition over here is that he need to subscribe the shares 50% or more than 50%. That is the main condition which need to be fulfilled. Otherwise, they will be liable to pay taxes. Now, the last one is like carry forward of losses or setup of losses, right? For this, I'll try to explain it with an example. Say, for example, 2 years back, startup incurred a loss, and they just want to just forwarded the loss, yeah, set up the loss in the coming years with the profits of the coming years. So they can do that. A condition has been over here inculcated that says that if your losses are there, then the shareholders in that particular year in which the losses were there, for example, in the year 17-18, you had a loss of for say 2 crore rupees, right? And in today's scenario, in today's current year, or in 1920, you have a profit of say 4 crore rupees, and you want to set up that loss of 2 crore rupees. So if the shareholders of both the years are same, then only you are eligible to set off the loss. Otherwise, you are not eligible to set off the losses under this section. Now, one more thing I'd like to tell you all this. These tax exemptions currently are allowed to the startups which are registered from 1st April 2016 to 31st March 2021. So these 5 years have been given by the government. Everyone who is being registering their startup during this period will be eligible to take the benefits of these exemptions. But due to this COVID pandemic and all these things, in the budget of 2021, they extended the period for 1 more year, that is now 31st March 2022. So now every startup which is being registered before 31st March 2022 will get all these tax exemptions which I stated just now. Now, the very basic questions which every entrepreneur or every startup should just consider is that there are 5 questions which we need to answer and which need to be answered to the department as well. The first question is, what is the problem the startup is solving? So as I told you that the startup should be a unique one, it should be have some kind of uniqueness. So now the problems which the product or the unique product will be solving need to be stated over here. The second question will be that how it is going to solve the problem, the process, how the startup will be working, and over this how it will be solving the problem. The third one is the uniqueness, the product which you are been presenting as startup or the services you are presenting as startup, how these will be like how this will be a unique one. This will has not been anywhere in the India or anywhere in the world, so that need to be explained very well. And the fourth one is how it will generate the revenue. Like we need to tell the model, like we need to tell how and what gradually what will the startup be doing so that the revenue generation start. Since the business has been the new one, so obviously we will not be able to generate the revenue from the day one, but we need to set up the plan for the 3 to 5 years, and then estimation will be made that how the revenues will be generated. And the fifth one will is like when a company has been incorporated, obviously it creates a wealth to the country, it creates economy to the country, and also employee generation is also being done. So we need to just explain as well how the wealth generation will be happening with this project and how much employment will be able to generate if the project succeeds. So all these points need to be answered before we are applying for the, it need to be answered to ourselves, it need to be answered to the department for applying for the startup. Now the basic and the major part which comes over here is the funding. The startup, since they have just the idea, they don't have any kind of funding. Usually the startups have don't kind of funding over here. So there are various methods through which they can just inculcate or just encourage or just raise the fundings. The one is the crowdfunding. This is like even an individual, a big firm, mutual funds, everyone can contribute to the startup if they found the idea very feasible. So this is a very general concept of crowdfunding. Like you can take any from your relatives or from your friends or a general public. You can just It's not an IPO you are raising and a initial public offer you are raising the money. It's just like you have the links and you're taking just the money from your links. The second one is self-funding. Some of the startups are from the very good backgrounds, so they have the initial investments. So this is a self-funding, like you yourself invest. This thing is a very good one, as the as if you further go into the market for raising further funds, so the investors also have a confidence in you, since you have invested your money in the startup as well. So there is a security in his mind that his funds are safe. The third one is the biggest one, the venture capitalists. So they are very much venture capitalists, mutual funds, UTIs, and all these things that that have ample amounts of funds, and they're ready to invest in the funds despite of the economic condition and despite of everything. But they just want is the good idea or the good prospect of the business. So to capture venture capitalists is a difficult task. But yes, if we are able to capture the venture capitalists, then they have a huge amount of capital to invest. Fourth one is angel investments. These are the shareholders, yeah, these are the investors which require much higher rate of interest for their investments. They have much capital in their hands to invest, but the problem with the angel investors is that they require a higher amount of what we say, higher amount of interest on their capital. So this sometimes become a hurdle for a startup, because the revenue generation is not that much to pay the interest on their capitals. And the fifth one is that the startup schemes. Under the Modi government regime, various schemes have been launched, and around 10,000 crore fund has been extended for the startup, which will be gradually be disposed of in 4 installment of 2,500. So if you are in the agriculture sector or in a sector that is underdeveloped and you are innovating something over there, so you can apply for these schemes, and if found feasible, then subsidies or financial aid at zero interest and many more other things are being provided into these schemes. So this is a very good initiative by the our government to just to encourage the person for the startup and encourage startups in India. Now, coming on to the benefits, what we get in terms of startup. The major benefit is reduction in cost and fee reduction. Now, if a company or a partnership firm is going to register for the startup, they get a cost reduction in terms of patents. Like if they, after the startup has been registered, if they want to have a patent registered, so around 80% of the government fees are being reduced for them. If like if I apply for a trademark, since we apply for a trademark, so we need to pay 4,500 rupees in case of individual, and in other cases, maximum cases, 9,000 is the fees. So if you have a startup registration, so the fees automatically gets slashed to 80% down. So you just need to pay 20% and you get a trademark or a patent or a copyright. So there is a big reduction in that regard. Now, easy access to funds in terms of startup can be like some startup get yes easy access, some get difficult access. That depends totally on the project. Tax holiday for 3 years, I've already above explained or have elaborated on that. Now, some of the tenders which the government raises or the private industries raises, that request for that are for only the startups to promote the startups. So if you have any kind of registration, then you can apply for tenders. And R&D facilities, the government currently have established 7 centers in all over the India. So any of the startup which want their products to be to more explore their products more after being getting the startup can just approach to these centers, and they are not charging any kind of fees from them to do R&D, research and development on their products. And the next one is no time consuming compliances. Like normally there is a time consuming compliances, but from the startup point of view, there are many exemptions been given to them. So the compliances are reduced. For example, there are 9 employment, like there are 9 labor laws, which the government has stated, under which the startups can self-certify them. They need not to go to anyone else for certifying their forms or certifying their returns, they can do themselves. So it automatically reduce their cost, also the time they consume in doing this. And 3 environmental laws have also been mentioned by the government, under which also self-certifications can be done by the startups only. The next one is tax saving for the investors. I already discussed above. And easy exit. Now, easy exit means like if a startup want to exit and doesn't want to continue on account of might be not be able to run it properly, or the revenues are not sufficient to run it properly. So within a period of 90 days from the date of strike off or wind up, the startup can take an exit, and they need not to further any kind of they need not to do any kind of compliances or any kind of headache on their part after 90 days. The last one is meet other entrepreneurs. That means that the government currently is like currently it is organizing 2 fest yearly for startups, completely for startups, and in that fest investors, stakeholders, various stakeholders, startups participate. So over there, there is a hub, so they can just explore the market. They can just bring more and more investors into their startup. They can just gain the knowledge of other startups, what the other startups are doing. So the government has taken various initiatives to boost up the startup process. Now, RBI also has given some kind of relaxations and some kind of ways how they can just take the money, or how can they fund the, like they can take the funding from the outside India. So in that regard, if a person resident outside India, okay, other than a resident or citizen of Pakistan and Bangladesh, these persons can invest in this startup up to an amount of 25 lakh rupees or more in a single tranche. So if a person who is resident out of India, who is a citizen of out of India, and want to invest in a startup that is being that has been in India, incorporated in India and running in India, he can just take the convertible notes from that startup and invest up to 25 lakh rupees. The reason why Pakistan and Bangladesh are being excluded over here is that there are some approval routes through which these countries can also invest, but from some restrictions in terms of terror attacks and all these things, these countries are being excluded from taking the money. Now, if the startup is under a sector which require the approval of the government or the RBI, then before issuing any kind of these convertible notes or before taking any kind of money, they need to take the approval of the RBI or the central government, and thereafter they can just issue the convertible notes and raise the money. Further, the convertible notes which have been issued presently, earlier it was 5 years, now it can be issued for the 10 years. A recent amendment has been came into the existence. So now the convertible notes can be issued for the 10 years. And while issuing these notes, the startup first should consider about the entry routes, like it is automatic or it is approval, sectoral caps. Some of the sectors has been capped by the RBI, which can take the FDIs or the foreign investment up to that cap only. Some are 100%, some are 74%. That depends on the work to work and sector to sector. Pricing guidelines, like the share price should be properly evaluated, and all the shareholders, all the a proper valuation report from a merchant banker should be taken, and all of the conditions for the foreign investor should be fulfilled. The next would be the startup company which are receiving the investment from the foreign countries, can just take the investment either through the normal banking channels or by debit of NRE, FC, NR accounts, escrow accounts of the concerned persons. Repayment and the sale proceed. Like if we have invested, if some person is investing in India, and obviously they would be, after a few years, will be requiring the money back. So the procedure for returning the money will be the same, the way they came in. Like if they have invested through normal banking channels, then they will be taking the money to normal banking channels, or by crediting to their NRE or FCNR accounts if they have an account operations in India of that account, right? So These are the conditions which the RBI has imposed, plus the NRIs and OCIs may acquire a convertible bond on non-reputable basis. Non-reputable basis means that they cannot take the money outside India. They just either keep invested in that project or invest in any other project in India, which allows the foreign investments, but they cannot go take the money out of India. Now the question arises that if an investor has taken a convertible notes and he needs the money or he doesn't want to be stay invested, so there is a provisions under the act that they can sell their convertible bonds to another outside person in India, outside the India. For that regard, we need to just take the pricing policies in mind and evaluation of the share price, and thereafter he can sell the convertible notes to the other person. Now, the reporting requirements in case we receive any kind of foreign investments. If a company, Indian startup is receiving any investments in terms of convertible notes, then they need to file Form CN within 30 days of the issue of the convertible notes to the authorized dealer bank. And the authorized dealer bank thereafter will be, after summarizing all the CNs, will report the RBI about the investment being received by the startups, right? And in case there is a transfer of CN by a person resident outside India to a person resident outside India, so that then they need to inform the startups about the transfer. The startup will thereafter inform to the authorized dealer bank of the transfer within 30 days, and authorized dealer bank will submit a consolidated statement of all the transfers, all the issue of CNs to the Reserve Bank. The period and the format has been prescribed by the Reserve Bank, and it's only available on the RBI sites. So in that regard, we need to do the reporting. Now, if there is an exemption given under Insolvency Bankruptcy Code 2016 also, if a startup is being registered and it is not running properly or it is not up to the mark, then the thing is that they can just go for the strike off or they can just go for the wind up. So if they have not able to pay any loans, or if they are under the IBC, or if a bank have declared them an insolvent company or insolvent firm, so there is a fast track corporate insolvency resolution process, so that the insolvency resolution process can be initiated and can be completed in a very few days. Like 90 days has been prescribed under the act. 90 days we can get just be insolvent, your wind up or whatever things will be done. There is a shorter process been prescribed under the Insolvency Bankruptcy Code 2016. So the startup can go over there. So if I conclude on that, oh, just for a second. Yeah. So government procurement exempted, like previously, if we talk about 2014, there was a time consuming process, no income tax exemptions, physical inspection was there when we apply for startups. Exit opportunity was 4 years. So it was a hassle free. After that, from 2018, all the things have been very, very smooth. So the procurements of orders is exempted over here. No kind of approvals need to be taken from the government before applying for the startup. Patent, if we are taking, like we get lots of benefit in terms of fee reduction and all this tax benefit we are getting much more. Now certification, I told you earlier also, labor law and environmental law, we can do certification on self, and a faster exit is of 90 days. So there are the main important, and the last one is that a panel provisions for this. Now sometimes the people are of the opinion that yes, we can go, since there is no fees for applying for the startup. So people are of the mentality that we can just go, if we get it, that is okay, and if it doesn't go, that is fine. But the act has specified a panel provisions. So if a client, if an applicant is uploading the documents and on verification it is found that the requirements are not up to the mark, or the wrong documents or false document have been uploaded, then the DPIIT can just penalize the applicant with either the 50% of the paid up capital or minimum 25,000 rupees. So minimum 25,000 rupees is the fine if you are making a forged application, or if your documents are not up to the mark, or you are just like making a time pass, what we can say, that you are just checking yourself whether we are eligible to get or not. So I would like to tell the members that we don't need to panic with this, seeing this penalty. This is being done for the peoples who are like creating a hurdle in the growth of the startups. If you are uploading the proper documents, if you are properly replying to the department, if you are very much serious with the project, then you definitely get the startup. And provisions are not so much harsh, and you get it so easily. So that's all will like to I will like to end up here with both the topics. So Vijay, any kind of questions or anything can be asked now.
Members are requested, if there is any query or doubt, you can please ask from our guest speaker, CS Gaurav Agarwal ji. Gaurav ji, chat box में I think एक दो
हाँ
query
कुछ हैं questions. हाँ हाँ जी
आप please take up करें.
Just 1 second, sir. Yeah. First question is that how ROC comes to know about that the company has not started its business. So in this regard, I'd like to just tell you that what is the thing is that the ROC is not coming to see you that whether you have commenced the business or not. It is like on the factors of like that ROC is of the opinion, or someone has complained, or the ROC itself thinks like there is a cases that this company hasn't commenced the business. If you have not filed a commencement of business form, then automatically you are yourself highlighting that we have not commenced the business within the 6 months, that 180 days. So it's up to the ROC whom they call and whom they visit to see that whether the operations are being in practice or not. So it's up to the ROC. It's not like this. On your part is only the form which you, if you have filed, then there is not a case that you're not doing the business. So it's up to the ROC only. The next question is, subsidiary of fully owned companies eligible for startup benefits. Yeah, like subsidiaries of wholly owned companies, in terms of this, if you are saying that a foreign company, then it is a big no. And if you are saying that it is an Indian company and that is a subsidiary, so of the subsidiaries under all the criteria I mentioned in my slides, so that they definitely can go for the startup, and then if they are granted with the startup registration, so they can just take the benefits of that. The next question is for startup companies, is it sufficient to start with a capital of 1 lakh or more capital is better? See, literally it is dependent on the applicant. Now the Companies Act have just erased the provision of minimum capital. So a person can start a company with a 1,000 rupees. It's up to you. It's up to the project which you are starting, the investment you need to start. See, because as I told you earlier also, the 5 questions which I mentioned over here, the one question was that how the startup will be generating the revenue. So in order to generate revenue, might have to make some kind of investments, but the act does not prescribe any kind of investment or minimum investment that can be done. Your investment can be in lakhs, crores. That's depend totally up to you. Vijayji, that is a longer process and will take a lot of time to how to register a startup company. You can just contact me and I'll let you know what can be done. So it cannot be right now answered. Vijay, I think so that all the questions has been answered.
Now I would like to over to Sachinji. I think okay, PPT will be shared to the members. I will take the PPT from Gauravji and will share to all the participants. Sachinji, please. Over to you, Sachinji. सचिन जी आपकी वॉइस नहीं आ रही है.
Hello, Vijay ji.
Yes, Sachin ji, audible now.
1 second, Vijay ji. Yes, thank you, Gaurav ji,
Thank you, sir.
for
Thank you
such
so
a
much.
wonderful
Sachin ji.
session.
Thank you,
You
sir.
explain it in very detail and in a very simple way. It was very
Thank you, sir.
informative and useful to all the participants. I
Thank
would
you so
also
much.
like to thank all our learned participant members for showing their zeal and eagerness to learn and join. Team Professional Gyan Kendra is always committed to serve the profession for members. Mittal ji, the founder of Team Professional Gyan Kendra, and all the team members for taking such wonderful initiative. Not taking much of your time, I would like to over to Mr. Vijay ji to complete the session. Vijay ji.
Thank you, Sachin ji, for your words. Thank you all the participants for joining us today for the knowledge sharing session. And thank you, Gaurav ji, for the wonderful session. You explained it clearly and answered all the queries very nicely and in a very simple way. I hope that it will be useful and informative to all the participants. And thank you to all my team members, our moderators, C. Sachin Jain ji,
Thank you,
CA
Vijay
JP
ji.
Jain ji.
Thank you, sir. Thank you, Vijay ji. Thank you, Sachin ji.
Thank you,
so
Vijay
much
ji.
for
Thank you.
I would also like to say thank you to all my team members for helping in organizing the session because it is a team effort and a single person cannot do this thing. And thank you to our guest speaker, CS Gaurav Agarwal ji, for the knowledge sharing session. With these words, I'm concluding the session over here. Thank you everyone for
Vijay
coming.
ji, sorry to interrupt you. Vijay ji, sorry to interrupt you. Some of the applicants.
Yes, please. Hello. Someone was asking something. If there is any doubt or query, you can please contact me personally. I will discuss with Gaurav ji and I will share the PPT with you. And with these words, I am concluding the session over here. Thank you everyone for coming. Thank you, friends.